MOOC on democratic awareness with legal literacy. Welcome to the class. Today's topic is role of police and executive in the criminal justice administration. The criminal justice administration is an uncodified system wherein the police, prosecution, judiciary and correctional administration play different specific roles for punishing the offenders and reformation of the offenders, so that the order of the society can be maintained properly. Naturally, the question arises, who is the offender? The person who commits the offense is an offender. Any act or omission punishable by law is an offense. Offenses are broadly divided in two broad categories, depending on the power of the police to arrest a person without warrant. The offense in connection with which the police has the power to arrest a person without warrant is called cognizable offense. The offense in connection with which the police has the power not to arrest a person without warrant is called non-cognizable offense. Now, whenever any offense takes place in the society, people go to the police station because police is the gateway of our criminal justice system. Whenever a person goes to the police station and reports about an incident in connection with an offense, it is the duty of the police to record the same in the police station, depending whether it is a cognizable offense or non-cognizable offense. Because the procedure of recording differs from cognizable offense to non-cognizable offense. This duty is discharged in the police station by the officer in charge of the police station. And sometimes the officer in charge of the police station is called station house officer. A police officer of the rank of sub-inspector of police or inspector of police is designated and posted in the police station to discharge the duty of officer in charge of the police station. In some states, they are called station house officer. When the designated officer in charge of the police station is not available in the police station physically, at that time, the senior most police officer above the rank of constable who is present in the police station, he will discharge the function of officer in charge of the police station. Law has given enormous power and authority to the officer in charge of the police station. That's why the senior police officers above the rank of inspector of police can also discharge the function of officer in charge of the police station. For example, any deputy superintendent of police, additional superintendent of police, senior superintendent of police, DIG, IG, additional DG and DG of the state can exercise the power of officer in charge of the police station. Similarly, in a police commissionerate, the officers who are equal to the rank of police officers starting from deputy superintendent of police to DGP can also exercise the power of officer in charge of the police station. Now, what is the object of the penal law? The object of penal law is to identify violation of those rights of the individuals which are required to be protected for maintenance of good order of the society. The other object of the penal law is to punish the offender so that again the order of the society can be maintained. Now, what is the role of the police in this regard? The duty of the police can be broadly divided in two categories. The first is The duty of the police is to collect information either directly or through source, and to make an analysis of the information and take preventive measures so that offence may not take place in the society. The second important duty of the police is to investigate the offence after commission of the offence. So, the first duty of the police is preventive action, which is connected with the executive magistrates. The second duty of the police is investigation of the offence, which is connected with the judiciary. Now, there can be unlawful assembly for maintenance of order in the society. The police will have to deal with the unlawful assembly, and that happens almost every day. What is unlawful assembly? Any assembly of 5 or more persons may be declared as unlawful assembly if the persons consisting of the assembly have the object of committing an offence, or to resist the execution of the law, or to do anything which may create law and order situation for which police will be responsible. So, the law has given huge discretion to the police to disperse the unlawful assembly. Any officer in charge of the police station, who generally must not be below the rank of sub-inspector of police, can give a command to the members of the unlawful assembly to disperse. If they do not obey the command of the police officer present in the spot, then the police can use force. This force must be a reasonable force for the purpose of dispersal of unlawful assembly. Once the assembly is dispersed, the police must not use again force, because that will be in violation of the human rights of an individual. When the police is using this force for the purpose of dispersal of the unlawful assembly, the police is protected from criminal prosecution. Law has given protection to the police so that he cannot be prosecuted under the law for committing any offence in discharge of official duty unless sanction is given by the government. Sanction is given by the state government, if the officer is working under the state. Sanction will be given by the central government, if the officer is working under the central government, and the appointing authority is the government. Now, what is the duty of the police after commission of a cognizable offence? I have already told that whenever any incident takes place connected with the offence, any person who is aggrieved by that incident can go to the police station and give the information to the duty officer. If the information discloses commission of a cognizable offence, then that information will be recorded as first information report, which we call FIR. If the information received in the police station discloses commission of non-cognizable offence, then the gist of the information will be recorded in the general diary of the police station, which we call GD entry. Now, when FIR is registered, then it is the duty of the officer in charge of the police station to take up investigation. He himself can do it, or he can delegate this power to any other sub-inspector of police or assistant sub-inspector of police to carry out the investigation. Sometimes the senior police officers may form a team of investigating officers headed by a senior police officer. Generally, officer of the rank of sub-inspector of police or inspector of police becomes the investigating officer. What is the duty of the investigating officer? The investigating officer will collect incriminating evidence, search any place, seize any document which is necessary for fixing criminal liability and to find out the offence which is made out in the particular case. So, to collect incriminating evidence, to search and seize the document, to arrest the offender, and to collect expert opinion. After that, on the closure of investigation, the police will form opinion whether it is a fit case to submit charge sheet or final report before the court of the magistrate. On completion of investigation, a police report is submitted before the court of the magistrate by the investigating officer. If the investigating officer has collected sufficient evidence to prosecute the offender, then that police report is called charge sheet. If the police could not collect, or the investigating officer could not collect sufficient evidence in order to prosecute the offender, then that police report is called final report. Once the charge sheet is received by the court of the magistrate, then the trial will take place. It will take place before either the court of the magistrate or the court of the sessions or the special court, depending on the nature of the offence. If it is a final report, in that case, it is the duty of the magistrate to give a notice to the informant who gave initial information in the police station for registration of FIR. So, informant will get a notice, appear before the court of the magistrate. He can raise objection whether he is satisfied with the investigation or not satisfied with the investigation. If he is satisfied with the investigation, in that case, final report will be accepted and the matter will be dropped. If he is not satisfied with the investigation, then there are two options before the magistrate. Magistrate, if satisfied with the materials collected by the investigating agency that cognizable offence is made out or any offence is made out, in that case he can take cognizance on the final report and proceed with the inquiry. Otherwise, he can give direction to the superintendent of police or to the commissioner of police in a police commissionerate to engage another investigating officer to carry out the investigation. That is called further investigation. On completion of further investigation, again a police report will be submitted in the form of supplementary charge sheet. Then again the same procedure will be followed and the magistrate will decide whether the trial will take place or not. Now, in course of investigation of cognizable offence or in case of preventive action, the police has huge discretion to arrest a person. To arrest a person means to take physical charge of a person by taking him into custody. So, for the purpose of arrest, the law has given huge discretion to the police officer, starting from the rank of constable to Director General of Police. Now, if the person who is to be arrested, if he resists the arrest by use of force, then the police officer who is going to arrest, he along with his team can also use force. And that use of force may extend up to the causing death of the person to be arrested, provided the person to be arrested is accused of committing a cognizable offence punishable with death or imprisonment for life. But generally, it is the duty of the police to use that much force which is proportionate to the use of force which is use of force on the part of the accused who is resisting the arrest. Now, this arrest can be done by the police in order to prevent commission of a cognizable offence, in order to disperse unlawful assembly. This is preventive part. And when the police is investigating the offence, the police can arrest the offender in order to interrogate him, in order to give security and protection to the victim of crime, or for collection of further evidence. So, for the purpose of arrest, the police can break open the door of a house if resistance is given and search the place and arrest a person. For this power of arrest, the territorial jurisdiction is no bar to the police. If any offence takes place in any particular police station, the officer who is investigating the offence can travel anywhere in India for arresting the accused connected with the offence. So, territorial jurisdiction is no bar to exercise the power of arrest. Now, only after arrest, when the arrest is done, after that police is prevented from use of further force, because I have already said that will be in violation of the human rights of the accused. That's why handcuff is not used in a routine manner on the accused person after arrest, that is prohibited under the law. Handcuff can be used on the accused only with the permission of the court where the case is pending, or with the permission of the magistrate where ultimately the arrested person will be produced after arrest. Now, in some cases where the arrested person resisted the arrest, became violent, and the police had to use immense force, in those situations the police officer can use the handcuff so that the accused may not escape from the custody, and when he will be produced before the court of the magistrate within a span of 24 hours, then the police officer who arrested the accused will have to give an explanation in writing why the handcuff was used. If the court or magistrate approves the use of handcuff, then the handcuff can be used in connection with that particular accused person at the subsequent stage of production before the court. Otherwise, handcuff will not be used in a routine manner on the accused person. Now, every person who is arrested, whether it is preventive arrest or arrest in connection with commission of a cognizable offence, the arrested person has a fundamental right to be produced before the court of the magistrate within a period of 24 hours from the time of arrest to the time of production before the court of the magistrate, excluding the time which is required for journey from the place of arrest to the court of the magistrate. The person who is arrested, he has some other fundamental rights which must be allowed to be enjoyed by the arrested accused person. What are those fundamental rights? The accused has a right to engage or to consult a legal practitioner of his choice. Accused has a right to know the ground of arrest. Accused has a right to inform any member of his family or any well-wisher or friend that he has been arrested, and it is the duty of the police who arrested the accused to inform the family members or relatives or friend or well-wisher that this person is arrested and where he is kept in custody. Apart from that, an arrested accused person has a right to be examined by a medical practitioner. So, the police will have to produce him before a medical practitioner for medical examination, and a report of medical examination must be produced when the accused will be produced before the court of the magistrate. And when the accused is arrested, one arrest memo is prepared where the place of arrest, time of arrest, the person in whose presence arrest was made, all these things must be recorded, and that memo of arrest must be produced before the court of the magistrate when the accused is produced before the court of the magistrate. Apart from that, the accused has the right to move the court for grant of bail. Because once a person is arrested, that means his liberty is curtailed. So, liberty of a person can be curtailed only by following the procedure established by law. If the court is of the opinion that there are not sufficient materials for further detention of the accused person in custody, then the arrested person will be released on bail. That bail can be granted by the court, court of the magistrate, court of sessions, or the high court or the Supreme Court. Now, when this arrest is made of an accused person, this arrest can be in case of a juvenile. Who is the juvenile? Juvenile means a male or a female below 18 years of age. So, a male or female below 18 years of age is called a juvenile. The juvenile who has committed any offence, he is called juvenile in conflict with the law. When a juvenile is in conflict with the law, has committed any offence, then the juvenile cannot be arrested and kept in detention. Once he is detained, he will be produced before the special juvenile police unit, and it is the duty of the juvenile police unit to produce the juvenile before the juvenile board for the purpose of conducting an inquiry. And during the pendency of the inquiry, juvenile board will give a direction to keep the juvenile in the observation home, not in the correctional home. What is observation home? A home just like children home. It is a home which is either maintained by the state or recognized by the state. Sometimes there are many NGOs who are given license to run observation home, but that is under supervision of the state. So, during pendency of inquiry, the juvenile will be kept in the observation home. There are many juveniles below the above the age of 15 years and below the age of 18 years who might have committed heinous offences like rape, murder, dacoity. So, when the juveniles are committing heinous offences which are punishable with death or imprisonment for life, and if the age of the juvenile is in between 15 and 18 years of age, then the juvenile board will conduct an inquiry to ascertain whether the juvenile had sufficient maturity of understanding at the time of commission of the offence, and whether he had knowledge about the consequences of his act. If he had sufficient maturity of understanding and if he had knowledge about the consequences of his act, then he will not be tried along with the other accused persons or in a regular court of sessions, but he will be tried before a children's court, where the judge will give appropriate reformative punishment. But the law has decided, the Juvenile Justice Act that has laid down that no punishment of life imprisonment or death sentence can be imposed on a juvenile. What is the role of the executive magistrate in the criminal justice system? Who are executive magistrates? The government selects the executive magistrates from the civil servants, and a notification is issued in this regard by the government. Generally, executive magistrates discharge their duty under overall supervision of the district magistrate in the district and under a overall supervision of the subdivisional magistrate in the subdivision. Executive magistrate has the power to deal with any public nuisance. If any obstruction is created on a public road or in a public place, then that obstruction can be removed, because that is a public nuisance. And the executive magistrate has also the power to issue an order for maintenance of public peace and tranquility in the locality. So by that order, any person can be restrained from doing anything. So that is done in order to prevent breach of peace in the locality. So the executive magistrate has the power and authority to pass any order against any person, restraining him to do something in order to maintain public peace and tranquility in the locality. The executive magistrate can also ask anyone to execute a bond of maintaining good behavior, bond of maintaining peace and tranquility in the locality. If there is an habitual offender residing in a particular locality and the executive magistrate has information either through any party or directly from the police, then that habitual offender can be asked to execute a bond for maintaining good behavior for a period not exceeding 3 years. Similarly, if a person has been making preparation for committing any cognizable offence, then also police can inform the executive magistrate or any individual can inform the executive magistrate to draw up a proceeding. Proceeding means an inquiry will be conducted, and that person can be asked to execute a bond for maintaining peace and good behavior. So during pendency of the inquiry, executive magistrate can also ask that person to furnish an interim bond, and on conclusion of inquiry, bond will be the final bond. If the person refuses to submit the bond, then what will happen? The executive magistrate has the power under the law to send that person to correctional home and to serve the sentence for the period for which he was asked to submit the bond. So that is the role of the executive magistrate. Apart from this, the executive magistrate, just like the police officer, I have already pointed out, can disperse the unlawful assembly. Executive magistrate can give direction to the police or even can call the army to assist the police for the purpose of dispersal of unlawful assembly. And when this power is exercised by the executive magistrate, if any offence is committed in course of discharge of duty, the executive magistrate is protected under the law from any criminal prosecution. If any criminal prosecution is to be started against the executive magistrate, then the sanction of the government is required. In case of executive magistrate of the state government must grant sanction for prosecution. Otherwise, executive magistrate cannot be prosecuted. Now, I would like to point out a few cases on the topic which has been discussed. The first case is Abhinandan Jha versus Dinesh Sharma. This is a case where long back the Supreme Court has laid down that the investigation is the exclusive domain of the police. The court cannot interfere. The court cannot interfere and give direction who is to be arrested and who is not to be arrested, which place is to be searched and which place is not to be searched, and which opinion is to be formed by the investigating officer. That is the exclusive domain of the investigating agency. But after submission of the police report, the magistrate may not concur with the opinion of the investigating officer. The magistrate will form opinion which is independent of the opinion of the investigating agency and can proceed in accordance with the law. The next case is Binit Narayan versus Union of India. In this case, this is known as Hawala case. In this case, the Supreme Court has for the first time laid down a principle which is called continuing mandamus. Mandamus is a one-time direction, but continuing mandamus, this principle is evolved by the Supreme Court to give direction from time to time. So when the investigating agency is not investigating the case impartially in accordance with the law, then the High Court and the Supreme Court can monitor the investigation by applying the principle of continuing mandamus and can give direction time to time only for the purpose of carrying out the investigation in accordance with the law impartially. That is the object. Now, another case is Joginder Kumar versus State OPP. In this case, the Supreme Court has laid down that only because a cognizable offence is made out against a person or allegation of cognizable offence is made against a person, that does not mean the police will arrest that person. Only because the police has the power under the law to arrest a person, the police must not exercise that power to arrest a person. The police will have to collect sufficient evidence in course of investigation to form the opinion that the arrest is necessary, and opinion must be a reasonable suspicion or a bona fide allegation, that opinion must be formed. Another case is Arnesh Kumar versus State of Bihar. In this case, the Supreme Court has subsequently, after Joginder Kumar's case, in this case the Supreme Court has laid down that only because allegation of cognizable offence is made out against a person, he need not be arrested. If the purpose of interrogation is served by issuing a notice to the person, if the person who is an accused responds to the notice, comes to the police station, faces the interrogation, then there is no need of arrest. So, arrest will be the last resort, because even in the Joginder Kumar's case, the Supreme Court has pointed out by quoting the report of National Police Commission that 43.8% of the arrest in our country is unnecessary, unwarranted. Next is Gauri Shankar Prasad versus State of Bihar. In this case, the Supreme Court has laid down that a public servant who is appointed by the state government or the central government, he may be a police officer, he may be executive magistrate, he cannot be prosecuted under the law for commission of an offence in discharge of official duty. So, if something is done by the police or by the executive magistrate as a public servant and that amounts to an offence, if that act of the police officer or the executive magistrate has any bearing on his official duty, then he cannot be prosecuted under the law without the sanction from the government. And this immunity is enjoyed by the police officer or executive magistrate when the appointing authority is the government. Otherwise, all public servants cannot use this immunity. Now, suppose a public servant has committed any offence which has no bearing on official duty. Suppose he has committed criminal breach of trust, misappropriated the property, or he has committed a criminal offence of outraging the modesty of a woman, or he committed the offence of rape, or any body offences which have no bearing on the official duty, then there is no need of sanction of the government. In those cases, the public servant, whether he is a police officer or executive magistrate, can be prosecuted under the law by any person who is aggrieved by that act.